Great. Good morning and happy Friday, everyone. Welcome to our live Q&A session today. I'm Jenny Lamb, and I'm the marketing director here at SJF Blog Group. I'll be moderating today's live Q&A and sharing our pre-submitted questions. We have attorney Lauren Burns here today also on the live Q&A to answer questions about probate. Welcome and thanks for joining today, Lauren.
Good morning. Thank you so much for having me, and thanks for moderating. And we're going to learn a lot about probate today, so I'm excited to get into everything.
Sorry about that. Also, I want to note that this live Q&A is currently also streaming on our Facebook, LinkedIn, and YouTube channel, so welcome from wherever you're tuning in from today. So now we'll be diving into our questions.
Before we dive in, I did want to do a little bit of housekeeping. So today's presentation is going to be some general questions about probate, things that we get asked the most often. We can't answer specific questions about your particular set of circumstances, but we do have all of our contact information here below at the bottom of the screen. So if you'd like to schedule a consultation with me or another attorney in the office, please feel free to do so. Today is going to be very high level. What is probate? All kinds of things related to the probate process. But for any questions related to specific circumstances or the facts about your particular case, will not be able to be addressed today. But we're happy to talk to you. So please schedule a separate time to come in and see us.
Great. Thank you, Lauren. So now we'll be diving right into our questions. The first one is, what is probate?
So what is probate? Probate, and when you hear I have to go through probate, or this has to go through probate, or the probate process, what that's referring to is the court process that is sometimes necessary to distribute someone's property to their beneficiaries after they pass away. It's not always necessary that something has to go through probate after someone dies, but when it is necessary, and we'll get to in a few minutes when it is and isn't necessary. But when something does have to go through probate, the probate process can oftentimes be very time-consuming and expensive, and it's something that can be very overwhelming to beneficiaries and personal representatives when they are already grieving the loss of a loved one. So probate is that court process where the judge is overseeing the distribution of someone's property to their beneficiaries or their heirs.
Got it. Okay, now this is the second question. When is probate necessary?
So when is probate necessary? It depends on how the particular asset is titled or whether it names a beneficiary. And if it does name a beneficiary, is that beneficiary still alive? Have they predeceased the person? So when you look at your or a person's assets, probate is determined at that time depending on how they're titled. So for example, with real estate, certain types of joint ownership where you own property with another co-owner, depending on how it's titled, it may avoid probate if you pass away. With other things like life insurance policies and retirement plans, financial accounts, it's going to depend on either how they're titled or whether they name a designated beneficiary on them.
Great answer. So now we're going to the third question. What is a personal representative and what do they do?
A personal representative is who is the executor of the probate process. In a few minutes, we'll get into the different kinds of probate processes that are available in Florida. But a personal representative in a formal probate administration is the executor. In Florida, they're called the personal representative. In other states, you may see terms like executor or administrator or something like that. So the personal representative is the person responsible and in charge of that probate process. They are representing the estate, collecting estate assets, they're addressing creditor claims, making distributions to beneficiaries, filing tax returns if necessary. So they're the person in charge of the probate process.
Now this leads into our next question. Are there different kinds of probate processes?
There are. So in Florida, I'm going to talk today about two different types of probate processes, the two main ones. So we mentioned, or we were talking about formal administration a couple moments ago. The two main types of probate processes in Florida are called formal administration and summary administration. The difference, or when one is appropriate over the other, depends on a few different things. The big one is the value of assets. So if you have property or assets that have to go through probate that collectively exceed $75,000, formal administration is appropriate. Formal administration is where you appoint a personal representative and carry out that probate process. Formal administration is much more involved. It's a lengthier process, takes a lot longer to complete versus summary administration. So the summary administration is an abbreviated and shortened form of probate that is appropriate to do, or you qualify to do, where the value of the assets is under $75,000, or where the person who passed away has been deceased for over 2 years. So depending on the facts, when was date of death, what are the assets, sometimes even when you have smaller estates, it may be appropriate to open a formal for a number of different reasons. We'll talk about that another day. But generally, formal administration and summary administration are the two main probate processes that you're going to see here in Florida.
Now, going into our next question, tends to be a common question. How long does probate usually take?
We do get this question a lot, and it depends on what type of probate you're doing. So formal administration is much longer. It's a much more involved process. It largely depends on the size of the estate, the complexity, creditor claims, beneficiaries. A number of different factors can have an effect on this. Formal administration generally takes anywhere from about 8 to 12 months. It can take much longer. Summary administration is quite shorter. Depends on the county and how quickly it can be resolved, but summary administration is typically between 3 to 4 months.
Going into another question, if you make a will, do your assets still have to go through probate?
This is probably one of the questions that we get the most often, and this sheds some light on a huge misconception or a big misunderstanding that people have about wills and probate. So oftentimes when I meet with clients for probate after someone has passed away, they'll say, well, I have a copy of their will. Why do I still need to do the probate process? And the reason for that is the will does not take you out of probate, or the will does not mean that you don't have to do a probate process. The will is only controlling what happens during that probate process. So it doesn't avoid probate. It just says what happens and who the beneficiaries are and who's in charge if you are going through probate. So even if you have a will, probate may be necessary depending again on how those assets are titled or whether they name beneficiaries.
Wow. Now, another question. What if you don't have a will when you pass away?
If you don't have a will when you pass away, the type of inheritance is called intestacy, or I should say intestacy law is going to dictate who your beneficiaries are. So when you make a will, when you create a valid will, you can name, with certain exceptions for spouses, you can name whoever you want to leave your property, your probate property. When you don't have a will and something happens to you, the Florida intestacy law provides a default inheritance scheme and lists who that person's beneficiaries are. This is a default inheritance scheme. So sometimes this is not always in alignment with people's intent, especially when we have people with estranged family members or spouses and children. So when you have situations where family dynamics are complicated, and a number of other different reasons. Even having a simple will can be very, very beneficial because, like I mentioned before, sometimes who the Florida legislature in the statute thinks a person wants to leave their property to is not always the case.
Oh, wow. Well, this is another good question that I'll be asking next. What happens to your debt when you die?
We get this question a lot. So when we talk about debt and creditors, there's a whole process in a formal administration regarding how creditor claims are addressed. So when you have, and I'm going to, for purposes of this discussion, speak directly on formal administration. So in a formal administration, there's something called the creditor period. The personal representative is responsible for making a diligent search for the person's creditors. So a reasonable, diligent search. They have to collect information on who did this person owe money to? Are there debts and loans, credit card payments, car loans, anyone that this person owed money to? The personal representative is responsible for collecting information on those creditors and then sending the creditors notice of the administration. And doing that gives them a window of opportunity to submit a claim for payment in the estate. So the personal representative is responsible for collecting information on creditors, sending them notice of the probate, and then kind of stepping back and seeing and waiting for any creditors to submit payments. If creditors submit a timely and valid claim during that probate process or during that creditor period in the probate process, then the claims are addressed at that point, and typically payment will be made from estate assets. It has to be a timely claim and it has to be a valid claim. So there's a whole process for dealing with creditors when you pass away. It's not appropriate to say, or sometimes I'll get asked, does my debt die with me? And the answer is no, but you kind of have to go through that analysis to get to the final answer.
And here's another good question. What can I do to avoid probate?
Certainly, avoiding probate is one of the main objectives of doing your estate planning. And oftentimes, after people go through the probate process, they'll also contact our office to do their own estate planning. There are a number of different tools that you can use to avoid probate, and some are better than others. Some of them carry more protection for your beneficiaries, but some ways that you can avoid probate are making sure that all of your financial accounts have beneficiary designations, that they have primary beneficiaries and contingent beneficiaries. Sometimes I have clients who come in where, for example, between married couples, where the husband had a life insurance policy that named a wife as the primary beneficiary, but the wife predeceased him, and then he never named a contingent beneficiary. So after wife passed away, husband never added a new person there, and then he passed away, and now that policy has to go through probate. So making sure that your financial accounts have beneficiaries designated on them is one way to avoid probate. There's also something called a ladybird deed that we'll talk about in a few minutes. Only for real property. Real ladybird deeds avoid the probate process. They're not perfect, but they are a easy and cost-effective tool for avoiding probate. A great way to avoid probate and offer a great deal of protection to your beneficiaries is using a revocable trust. And revocable trusts are a great estate planning tool because aside from avoiding the probate process and offering a lot of creditor protection and disability and incapacity protection to your beneficiaries, revocable trusts are also applicable to all different kinds of assets. So they're not just for real estate or financial accounts. You can fund your revocable trust with all of your property. So they're a really great way to avoid probate and protect your assets and your beneficiaries as much as possible.
Oh, okay. And then I know you have a few other questions that you are going to address that you have on your end.
Right. We got a few questions submitted before today's presentation. So one of them we spoke a little bit about. I'm going to read the question now. If you have a ladybird deed, which eliminates probate, will your other personal property or debts still need to go through probate without a will? So let's break this question up into a few parts. The first part, if you have a ladybird deed which eliminates probate. So while the ladybird deed will, if you have a valid ladybird deed, it will eliminate probate for that particular piece of property. So that real estate that's described and subject to that ladybird deed will avoid the probate process. Your other assets may or may not also, or may or may not need to go through probate depending on how they're titled and whether they name beneficiaries. Another reason, spoke about this a few moments ago, why a revocable trust is such a great tool, because you can put all of your property into it. Where you only do a ladybird deed with respect to one piece of real estate, you run the risk of other assets needing to go through probate. So I hope that answers that question. The second question is, if you have a will stipulating all previous items, will probate be unnecessary completely? So this brings us back to one of the things that we first talked about, which is that probate doesn't, or a will doesn't avoid probate. It just says what happens during the probate process. So even if you have a will that leaves your property to your beneficiaries, you may still need, you will need probate depending on how that asset is titled. So for example, if you have a will that says, I leave my bank account to Jenny, but that bank account names me as the beneficiary, it doesn't matter what the will says, because beneficiary designations trump the will. So the will only comes into play when something has to go through probate. Because that bank account has a beneficiary on it, it goes to me. It doesn't matter that it's left to Jenny in my will. And if you have a will that says I leave all of my property to person A, but person B is the designated beneficiary on everything, it doesn't matter what your will says. The last question that we have is, if a person has another person, like for me, a son or a daughter, does this keep those assets from being frozen when I die? Does it keep that money from going through probate? And to take this question apart a little bit, what I think the question is driving at is, if you have a bank account, for example, or a piece of property that names someone else on it, if something happens to you, does it need to go through probate? And it brings us back to the same conversation that we had before. It depends on the titling and the ownership. So I see this very often with bank accounts, where a parent will have a child as a joint owner on the account with them. When you have an account owned by two people jointly, if something happens to one person, that account goes 100% to the survivor. So it does avoid probate if it's jointly held like that. We don't recommend owning property jointly with children for many different reasons, again, outside the scope of today's conversation. There are better ways to address that. With respect to real estate as well, when you have someone else on title, it depends on how exactly they have and share that joint ownership. You can own property jointly as a tenant in common with someone else, or with rights of survivorship. So it really depends. I'm going to open up the chat. Any questions? If anyone wants to submit a question here in our chat box. Otherwise, I'm going to turn it over to Jenny for any closing remarks or any final questions that were not yet addressed.
There isn't any other questions, so if no one has anything else, that's going to be all for today's program. So thank you everyone for joining our live Q&A today. Make sure to follow SJF Law Group on social media to get our latest updates and other great information. I'm going to drop the link to our social media in the chat box right now for everyone. And then check out our website for informational blogs and other great free resources.
Thank you everyone for joining. I hope you learned a lot about probate. If you have any follow-up questions or you want to schedule a consultation with us, please feel free to reach out. And thank you again so much for joining. I hope everyone has a great weekend and looking forward to seeing you all soon on a future Q&A panel.
Thank you and have a great day, everyone. Bye.